the expedited accusation calendar, in which individuals who've been charged with criminal misdemeanor offenses, their cases have already been formally accused by the Solicitor General's Office of Fulton County. This would be the defendant's initial appearance before a judicial officer, at which time he or she will be informed of the accusation number, the charges brought against him or her, who is the appointed counsel, as well as a bond, and if possible, your next court date. If you're a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say about the facts of your case during the course of this recorded and live stream proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we have attorneys from the Public Defendant's Office or the Conflict Defense Office who will represent you. Okay, courtroom 2, who do we have?
Your Honor, before we get started,
This is going to be.
Just one second. Let's start with courtroom 2. What's the announcement?
I'm sorry. I don't know who that was talking. Okay, position 7, Mr. Jones.
Okay, Ms. Duncan, what were you trying to say?
my apologies for interrupting. The state is going to be requesting that the court hold positions 9 and 12 to the end of the calendar.
Okay, just remind us.
For what position?
9 and 12, they're co-defendant cases.
9 and 12, okay. Okay.
All right, so I'm sorry. Francois, I forgot. Was that position 2?
No, this is position 7, Mr. Jones.
7. This is Keithan Cortez Jones, accusation number 23 CR 000196G. Mr. Jones has been accused of 6 misdemeanor offenses: possession of marijuana less than 1 ounce, violation of rules at a bus rail station, willful obstruction of an officer. That's 1, 2, 3 counts of willful obstruction of an officer, and the 6th offense is criminal trespass. This is from January 11th, 2023. Mr. Jones, you've been advised of your right to remain silent, and your attorney is going to be Ms. Wanda Gant. Is it Mr. Howard who's the pretrial? Okay, Mr. Howard, any priors?
6 total. Last was 2021, theft by taking. 2014, trespass conviction. 2014, probation. Another trespass conviction, 2013. Misdemeanor possession of marijuana conviction, 2012. That's it.
Thank you. Ms. Todd, good afternoon.
Good afternoon, Your Honor.
And what is the state seeking?
Your Honor, yesterday, the defendant, even though he has this active suspension from MARTA, while working a plainclothes detail on MARTA train 407, officers Bailey, Point du Jour, and Peters witnessed the defendant holding a clear bag containing a brown paper cigar and what was suspected to be marijuana. The officers approached the defendant as the train arrived at the West End MARTA station, identified themselves as MARTA PD officers, gave the defendant a command to place his hands behind his back. However, he refused. All 3 officers gave the defendant numerous commands to either stand up, remove his hands from his pockets, and place his hands behind his back. After a continued difficulty, the officers were finally able to place the defendant in handcuffs and escort him off the train. The state is seeking a $3,000 signature bond, Your Honor, through pretrial services. That's $500 on each of the 6 counts. We are also asking that this MARTA suspension be upheld here in your court today, Your Honor, with a stay away from all MARTA facilities, as well as no drugs, alcohol, or weapons while on bond.
Any objection, Ms. Gant?
No, Your Honor, thank you.
Each count is going to be a $500 signature bond through pretrial. Mr. Jones, you can sign up for your bond. The total bond is going to be $3,000. At the present time, you won't have to pay for your bond. However, you're required to stay away from all MARTA property, including bus and train stations, as well as the vehicles, the buses, and the trains. You cannot be using any of their facilities, including the parking lots, the bathrooms, or any other location. So please be mindful that if you go back to a MARTA property and you're arrested again, You will be brought back to jail and your $3,000 signature bond will be revoked and converted to a surety bond. Your next court date will be sent to you at your current address, and the one we have for you is 2879 3rd Avenue. Would that be correct?
Oh, yes, ma'am.
All right. Make sure you show back up. Yeah.
I wanted to ask one thing. Would it
Um,
be? okay to
Mr.
get my-
Jones, Mr. Jones, I'll give you a call at the jail about your bond conditions or any questions you have, okay?
Okay.
All right. Just right now, you have to stay away from all MARTA property and no illegal drugs, no alcohol, no weapons, and no firearms. Marijuana is still illegal in Georgia. So if you're still in Georgia, no weed. Thank you.
Thank you, Your Honor.
Hey, Daphne, come on in.
Position 10, Posey.
They want to see how long you're gonna be here.
Sorry about that. We are apparently under a storm warning at the courthouse, so let's move on. This is position number 10.
Yes, Posey.
Mr. Michael Posey is case number 23 CR 0000187Y. He's been accused of criminal trespass and violation of certain rules at the bus or rail from yesterday. Mr. Posey, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Mr. Howard, any priors?
I don't have that file. I thought this case was sent to felony.
I can
All right.
clarify for the court if Your Honor would like.
Yes, please. Ms. Duncan?
This defendant does in fact have 102 cycles, not including this cycle, and Mr. Howard was correct. There were 2 cases that were brought against the defendant in this case this morning. However, the first was a recidivist theft by shoplifting, and that was accepted by the DA's office this morning. This case in particular did occur on January 11th, 2023, which was yesterday at the East Point MARTA station. The defendant was witnessed on the property of East Point MARTA station with an open alcoholic container and causing disruptiveness on the train, yelling and cursing at other patrons. There was a suspension check for this particular defendant, and he did have in fact an active suspension that was effective December 21st, 2022, that does not expire until February 19th, 2023. This defendant does present a severe risk of reoffending. Your Honor, this defendant just has criminal trespass
Yeah,
conviction.
I noticed he was just released, and I'm familiar with his record. What are you recommending for these 2 new charges?
So the state is recommending a total $2,000 surety bond, given that he was just released on criminal trespass plea. That's $1,000 per count, and we're asking for a stay away from all MARTA. We do also have some concern that this defendant is a flight risk. Upon my research, I saw at least 3 FTAs from the from the last 3 years, and we have some concern about his ability to respond positively to the legal process, given that he does have several probation violations in the last 3 years as well. In addition to that stay away, we're going to be asking for no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Ms. Kim?
Yes, Your Honor. Mr. Posey is 57 years old. He was born and raised here in Georgia. He went to serve Army from 1988 to 1993. He was discharged with honorable
discharge?
Yes, he
Okay.
was, yeah. And he also has an associate degree. He has been gainfully employed at Dunkin' Donuts as a cook for the last 5 years. So we would like to request for a signature on bond. He already has a $15,000 bond from the felony charge that he was accused of, and also this criminal trespass and certain acts. We would like to request for a signature on bond. If Your Honor is not inclined to give him a signature on bond because of the past history, we would like to request for a maximum $1,000 good bond total. Thanks, Your Honor.
$500 on each count. That's $1,000 surety bond. Stay away from all MARTA property until further order of the court. Next court date is going to be, is it January 24th?
January 4th,
Is that
Thursday the
correct, Mr. Jordan? January 24th?
26th. January.
26th. Next court date is January 26th, 9 a.m. Thank you.
For the misdemeanor?
Yes.
Yes, sir.
All right, when,
I'm so sorry. He's been muted. Mr. What were you asking, sir?
when do I go back for the felony?
I don't have that date. They should have informed you at the felony first appearance.
Hmm.
All right, thank you.
Go ahead, Sarge, you can go.
Come on,
The
folks.
visitor is here for, courtroom 3.
All right, courtroom 3.
Position number 11, Judge, please.
All right. In courtroom 3, I just want everyone who is charged with an offense in that courtroom to know that you have a right to remain silent. Anything you say about the facts of your case while I'm
Ma'am,
addressing.
come on, ma'am. Come on, please. Oh, I'm sorry, Judge.
Okay, sorry. All right. As I was saying, for those who've been accused of a criminal misdemeanor offense or offenses, you have a right to remain silent. Anything you say about the facts of your case during the course of these proceedings, your statements can and will be used against you. You have a right to an attorney, and one of the public defense attorney on the Zoom screen will be representing you. Sarge, could you repeat again, which position was this?
Position number 11.
11. We have Yanya Rainey, accused of battery and disrupting a public school. Her accusation number is 23 CR 0001998. Ms. Rainey, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim.
Also, quick, Judge, we got visitors here for them and they want to speak as well. I believe.
Where are the visitors?
In the gallery in courtroom 2.
Okay, understood. Thank you.
You're welcome.
Mr. Howard, any priors on Ms. Rainey?
No.
First arrest?
Yes.
Thank you. Ms. Todd?
Thank you, Your Honor. Yesterday at Maynard H. Jackson High School, the defendant was recorded on video punching, kicking, and stomping on a Miss Journey Jackson, both common spelling. Yesterday during school, the altercation caused quite a scene requiring staff and faculty to intervene. As a result of this incident, Miss Jones was transported to a nearby hospital due to the fact that she was exhibiting symptoms of a concussion. The state is asking for a total $4,000 surety bond. That's $500 surety bond on the disrupting public school and $3,500 surety bond on the battery. We are also asking for no further contact with Miss Journey Jones. We are asking that the defendant be required to comply with any active school suspension. However, when that suspension is up, return to school daily. We are asking for a curfew from 8 p.m. to 6 a.m., 1 day of anger awareness, and no drugs, alcohol, or weapons while on bond.
All right. Are all those individuals in courtroom 2 in the gallery there for or on behalf of Ms. Rainey?
Yes, Judge.
Okay, I just need one person. They can pick who they want, who is going to speak on her behalf.
Which one you all coming in? One judge. So you don't have both of them.
And we gotta keep it moving, y'all gotta make your mind. No, that's my bad.
All right, good afternoon. My name is Judge Lal. Who am I addressing?
LaKendra Graham, you know, you Rainey's mother.
Repeat that?
LaKendra Graham.
Lakinda Graham. Okay, and I'm sorry, how are you related to Ms. Rainey?
I'm her stepmother.
Stepmother, okay. And Ms. Graham, if you'd like to say anything, I need to place you under oath. Would that be all right?
Yes.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Well, As you've heard, what the prosecutor has indicated allegedly occurred yesterday at this school. What would you like to tell me?
Yanya has a job. She works at Papa John's. So the curfew hours, are kind of like, I don't think that it's a good time for her because she has a job.
Anything else?
And her sister also, well, the altercation started with Journey attacking Yanya's sister. And her sister is on crutches from an incident that happened a couple of days prior to that. I also have evidence and video footage.
So there was an incident with Yanya's sister a
Yes.
few days ago.
No, yes. The two young ladies jumped Yanya's sister the day, I think like a couple of days before that, and her sister was on crutches with a splint on her leg.
So
And,
this retaliation occurred more than 48 hours later?
Yes, Journey attacked Brianna in the hallway. And the incident happened, so I don't know if they have the beginning of the footage, but I have footage from the kids at school.
Okay. Anything else?
No, that'll be all.
Okay. I'll let the deputy direct you back to the gallery. Thank you.
Thank you.
All right, Miss Kim?
Yes, Your Honor, Miss Rainey is 17 years old. She's a full-time senior at Maynard Jackson High School. She's expected to graduate on May 2023. Her GPA is 3.5, a very excellent student. She dreams to be a biologist because her favorite subject is a science. I would like to request for a signature on bond, and Miss Lakendra, her stepmother, is willing to be a co-signer, so she can go back home and return to school.
Does Miss Rainey live at the Trestle Tree Court location?
Yes, Your Honor.
And does Miss Graham live at that location as well?
Yes, they live together.
On disrupting a public school, it's going to be 1,500. On the battery is going to be 4,500. Her total bond is 6,000. It's a signature bond through pre-trial services with conditions. What this means, Miss Rainey, is that I'm going to really have you released on a signet. Oh, I'm so sorry. Can you hear me?
We can hear you.
Yeah, we can hear you.
All right, I think my video might just be frozen, but
Yes.
okay. But as long as you can hear me, as I was saying, you're going to be complying with certain conditions while you're released on the signature bond. If you violate these conditions, you could be arrested, brought back to the jail, and your signature bond will be canceled and converted to a $6,000 surety bond or a cash bond. So it's very important that you comply with these conditions. Well, the conditions are as follows. I'll need apparently Miss Lakendra Graham is going to be the co-signer. So we're going to have her listed as the co-signer. Mr. Howard, I'm not waiving the utility requirement. So Ms. Graham will need to come down to pre-trial to co-sign the bond. In addition to that, she'll need to bring a utility bill, in which the bill has the same address and Ms. Graham or a household member of that address on that name. Would that correct, Mr. Tucson?
Sure, yes.
Okay, I'm not
I can
certain
hear
what's
you.
going on. Okay, I'm not certain what's going on, but I think my Zoom is about to close out. I will leave the Zoom and come back in. Sure.
Mr. Fountain, you need to, put a shirt on.
Hey, Ms. Duncan.
Yes,
Hey, for, you said for position, I just wanted to make sure that was correct. Position 9 and 12, you guys want to do a breakout, right?
no, we just want to hold it to the end of the calendar.
Oh, okay, I thought it was a breakout. Okay.
All right, I'm sorry about that. As I was saying about Miss Yanya Rainey, her stepmother will co-sign the bond and she will need to bring a government issue ID and a utility bill. No further contact with Journey Jackson, to stay away from the Maynard Jackson High School in accordance with any active suspension issued by that particular school. The school will also be directed that Miss Rainey cannot attend any of the same classes as Miss Jackson. And Miss Rainey, if you are at the school and Miss Jackson happens to be like in the hallway or in the cafeteria, you're required to turn around and walk. Where is she? Oh, there she is. Okay. You're required to turn around and walk away. No alcohol, no illegal drugs, no weapons, and no firearms. So if there are any firearms in your home in which you live with Miss Graham, you need to make sure that the firearms are gone. Yes, I do understand that you have a job, but unfortunately, due to the egregious nature of the charges brought against you, you are going to be subject to a curfew from 8 p.m. until 6 a.m. You are to make sure that you are home by 8 p.m. and that you are allowed to step out of the home only after 6 a.m. And while you are out of the home, you're only permitted to go to school, to seek medical attention, to attend court or speak to your attorneys, to attend church, and to attend school if once the suspension has been lifted. Please understand you're under a strict curfew condition. If you're outside of your home for any other reason but the ones I've just listed, you could be subject to arrest and a revocation of your bond. That concludes this case. Thank you.
Your Honor, really quickly, if I may, I believe I misspoke during the presentation of my case. The victim's name is Journey Jones, not Journey Jackson.
I'm sorry, Journey Jones. Okay. Got it. Thank you.
I have position number 1 next, please. Come on, Ms. Bell.
Ashley Bell is accused of battery, family violence, and cruelty in the 3rd degree from July 10th, 2022. Ms. Bell, you've been advised of your right to remain silent, and your attorney is Ms. Gant. Mr. Howard, any priors?
It's a third arrest, 2020, 2009 DUI. All I have.
What happened in 2020?
DUI is what I have. Did she
Okay.
say something? She said it's not her? What happened?
I've never been arrested
They,
before.
Ms. Bell, please remain silent.
Saying she's never been arrested.
Hey, you got something different?
I have no previous charges in GCIC.
All right, we roll with that.
All right. Ms. Dillingham, what's your bond recommendation for this case?
Good afternoon, Your Honor. So this incident occurred, as you said, in July 10th of 2022, where officers responded to the QT gas station at 630 10th Street, Northwest Atlanta. The defendant and the victim were in the midst of a exchange of their 6-year-old daughter when an argument ensued. The victim, Raphael Gentry, told the officers that defendant began striking him in the face and arm in front of their 6-year-old daughter. And upon arrival, officers observed lacerations and scratches to Mr. Gentry's arm. So the state is recommending $4,000 surety bond, $3,000 on the battery, family violence, and $1,000 on the cruelty to children. No further contact with Raphael Gentry and a third-party transfer for the child.
All right. Ms. Gant?
Thank you, Your Honor. Ashley Bell is 33 years old. She has been in the Atlanta, Georgia area her entire life. She does have family here, including a 6-year-old child. She also has parents here. Ms. Bell is actually divorced from the complaining witness, Mr. Raphael Gentry. They were married in 2016. However, Your Honor, Ms. Bell reports that he was abusive in the marriage. She filed a TPO in 2016 and they had been separated since that time. She states that during that time, he choked her while she was pregnant. A little bit more about Ms. Bell. She completed high school. She does have a bachelor's degree. She studied communication and journalism. She attended Georgia State. She is the sole provider. Let me back up. She is the primary caretaker for her 6-year-old daughter that she shares with Mr. Gentry. She does have a court order. She was awarded primary physical custody, although they do share in joint custody. It is my client's wish that Mr. Gentry be able to see his child. However, my client does not want to have any contact with Mr. Gentry whatsoever. My client strongly denies the allegation. She states that on the day in question, July 2022, they were in fact exchanging the children. She states that it is Mr. Gentry is the person that became violent with her. He hit her and she states that she was merely acting in self-defense, Your Honor. She does not have any prior history whatsoever. And I would just bring to the court's attention that this warrant was dismissed by the prosecutor back on August 3rd of 2022. My client was unaware of this warrant. So for these reasons, in light of her lack of criminal history and clearly my client's history of violence that she has endured by her husband, her former husband, we are requesting a signature bond on Ms. Bell's behalf. We are unopposed to the no contact order, Your Honor. Thank you.
Okay, news to me. There was a prior warrant that was dismissed.
In the Odyssey report that I received, it's the same. The warrant was dismissed August 3rd, 2022, and then it appears that I believe that was reinitiated on the 10th or the 11th, Your Honor.
Your Honor, the warrant was not dismissed. Clearly, we would not be here today if it was.
I have an August 2nd, 2022 warrant.
I retrieved that information from Odyssey. That is in the warrant that I read, Your Honor, this morning, that the warrant was dismissed, and it states that the specific reason is that the prosecutor dismissed the warrant.
What's the warrant number that you're reading?
If the court's indulgence, I'm happy to pull that up.
There's 2 attachments on the jail screen with the same warrant. There's a warrant that says EW 0371531. It says it was dismissed, and then there's another warrant that says, sorry, it's the other on the screen. EW 0371532 was dismissed. So there's 2 attachments on the jail screen for this case.
Okay. But the one we're going with is EW 0373038. Is that the one that the prosecutor is going with?
I beg the court's indulgence, Your Honor. I'm pulling it up just one moment.
I'm trying to look at this as
So,
well. Mr. Jordan, where do I need to be looking for this, where this warrant was purportedly dismissed?
If you go to the jail screen, so there's two attachments, the two that was dismissed and then the two new warrants.
Okay,
On the
okay.
document on the jail screen.
No. Okay, hang on. I understand. Okay. There were warrants that were filled out. EW-0371531 and EW-0371532. Those warrants were never signed by the judge. So those warrants were never executed. They were never executed. So those are being disregarded. The warrants that are prevailing in this case is EW-0373038. Which is for the battery offense. And EW-0373039. These warrants were signed by Judge Reggie Williams on August 2nd, 2022. About a few weeks after the original warrants were never executed. So there was nothing to drop or withdraw or anything. I have no idea why they were not signed.
So,
All right.
Your Honor, I think we can all agree there is a vast difference between an unsigned warrant and the prosecutor dismissing a warrant.
I've already made that point. So I'm going to move on to the issue of bond. On the
I'm sorry, Judge Law.
yeah.
Sorry to interrupt. I do have the parents here for Ms. Bell and would like to say something on her behalf.
And
No,
Your
that's
Honor, we are opposed to any testimony from Ms. Bell's parents. They are not parties to the case.
folks. The battery is going to be $3,500. It's a signature bond through pretrial services. The cruelty to children charge is a $1,500 signature bond through pretrial services. Her total bond is going to be a $5,000 signature bond. She won't have to pay anything today, but she will need to report to pretrial once a month. She will have no further contact with Ralph Gentry. Stay 200 yards away from him. Do not communicate with him in any way, form, or manner. There shall be third-party transfer of the child or the children that she has with Mr. Gentry, only to be done through a third-party contact. In other words, she cannot be present for the when Mr. Gentry exercises his visitation or joint custody rights under the divorce decree. It has to be done through a third party. So it can be done through a mutual friend. It can be done through a person that is mutually acceptable to both Mr. Gentry and Miss Bell. I don't know if her parents are one of those individuals. No illegal drugs, no weapons, no firearms. And Miss Bell, while you are out on a signature bond, you will attend and complete 12 weeks of anger management classes at your expense, and you will attend 2 parenting classes. Your next court date will be sent to you at your current address, which we have as Pebble Beach Drive. Is that correct? Okay. No illegal drugs, no alcohol, and you're not allowed to possess or own any weapons or any firearms. So make sure that if you do own them, you surrender them to the local authorities. Your next court date will be sent to you to the address I've just listed. The 12-week anger management classes and the two parenting classes must be completed within the next 120 days after you're released from the jail. Understood?
Yes, ma'am.
Thank you. Next case, please.
Position 4. Pronounce your last name? Dicico.
Lucio Dicico, case number 23 CR 0000200E, is accused of 10 separate misdemeanor offenses arising from a traffic incident of January 2nd, 2023. The 10 offenses are as follows. Driving under the influence of alcohol, less safe. Driving hit and run, failure of the driver to stop or return to the scene of the accident. That's 2 counts of hit and run. No, excuse me, that's 3 counts of hit and run, failure of the driver to stop or return to the scene of the accident. And 6 separate counts of failure to report striking a fixed object. So that's 6 counts of failure to report striking a fixed object. 3 counts of hit and run, failure to stop or return to the scene of the accident, and 1 count of DUI, driving under the influence of alcohol, less safe. Mr. Dicico, you've been advised of your right to remain silent. Your attorney is Ms. Wanda Gant. Mr. Howard, any priors?
Yeah, 3rd arrest. Last arrest was 2021 in Roswell for DUI, hit and run. Before that was 2006 DUI. He was acquitted.
Thank you. Ms. Dillingham?
Yes, Your Honor. This incident occurred on January 2nd, 2022. Officers responded to 2110 Waters Edge Trail, where they were alerted of the defendant who was driving under the influence of alcohol when he hit 6 mailboxes at the residence of 2110 Waters Edge, which is an apartment complex. After the defendant left the scene without assisting in any of the damage that he caused, he then pulled into a parking lot of a Home Depot at 870 Woodstock Road, where he hit 2 parked cars in that parking lot and then continued to drive away. It wasn't until he was stopped at the Wells Fargo parking lot at 850 Woodstock Road after he had hit yet again another car that was parked. When officers responded, they could smell a heavy odor of alcohol on the defendant's breath and person. The defendant refused a breathalyzer, but the officers did find and confiscate a bottle of Smirnoff, an open bottle of Smirnoff, in the defendant's car. And Your Honor, as pretrial stated, this defendant does have a long history of driving under the influence, and due to the defendant's blatant and deliberate disregard for the safety of others around him, the state believes that this defendant is a danger to this community and at a severe risk of reoffending. And the state is requesting a $30,000 surety bond, $6,000 on the DUI, $3,000 on the hit and runs, and then $2,500 for the 6 failure to report striking fixed objects. No drugs and alcohol and no driving.
Ms. Gant?
Thank you, Your Honor. Mr. Lucio Dicico is 53 years old. He has been in the Atlanta, Georgia area. Well, actually, he's been in Georgia since 1996. He resided in Augusta. He relocated to the Atlanta, Georgia area 3 to 4 years ago. He is the proud father of 2 children, ages 17 and 11. He was married. He recently divorced and, of course, endured some financial difficulties arising from that divorce and the dissolution of assets. He does have a multi-$1,000 child support obligation each month, Your Honor. Mr. Dicico has a bachelor's degree in accounting and auditing. He is currently employed in a temporary position. His employment ends in March of 2023. He works for a temporary agency for a local accounting firm, Your Honor. Prior to obtaining this job, he was unemployed for about 4 months, and he informs me that he is in need of hip replacements and that he has difficulty walking. He's very concerned about just his finances in terms of being able to meet things that are coming down the pike for him, including having the ability to afford in-house care for him when he undergoes his knee replacements. Mr. Dicico denies the allegations, Your Honor. He is presumed innocent, and we disagree with the state's contention that he has a long history. As we heard from pretrial, he was acquitted of a DUI in 2006, and we know that he is presumed innocent in all open cases, including this one. He states that on the day in question, he actually blacked out. His blood pressure was found to be very high, along with his heart rate. I do have some concerns about my client's ability to make that bond amount, Your Honor. I am requesting on Mr. Dicico's behalf a bond of no more than $5,000, and it is a split bond. We are requesting, let me make sure that I get my math right here, $2,000 for the DUI, $2,000 for the DUI, and I'm sorry, $2,000 for the DUI, $1,000 for each of the hit and runs, and a signature bond for the failure to report striking an object, Your Honor.
Okay. On the DUI, driving under the influence of alcohol less safe, the bond is going to be set at $4,000 surety bond. While each count of the hit and run is $1,000 surety bond. So that's a total of a $7,000 surety bond. For the 6 separate counts of striking a fixed object, that's going to be $1,000 in each count, and that's going to be a $6,000 signature bond through pretrial services. The total bond is a $13,000 split bond. Next court date is January 26. While he's released on bond, he will report to pretrial once a month. He is not to consume any illegal drugs, no alcohol, and be subject to mandatory screens by pretrial services every month. He's not to consume, he's also to undertake an alcohol and drug evaluation by a qualified provider within 30 days of being released. And he must show proof that he's attended such an evaluation and must subject himself to any treatment as required by the evaluator at his expense. As I said, his next court date is January 26. Thank you. Oh, one other condition. I'm so sorry. One other condition. No driving unless permitted by the Department of Driver Services. So presently, his license is subject to revocation pursuant to the DUI. And unless he files the appropriate documents, it will be suspended after 30 days. Thank you.
And Your Honor, just for clarity, the DUI, you ordered 4,000 surety and 1,000 for each of the hit and run.
That's correct. That's a $7,000 surety.
Thank you, Your Honor.
Wait, for the hit and run, that's a signature bond or that's the surety?
All surety. The only thing that's signature is the striking fixed objects.
So I can draw.
Thank you.
Position of receipts is next, please.
State versus Ebony Jones, start charged with battery, domestic violence from September 18th, 2022. Ms. Jones, you've been advised of your right to remain silent. Your attorney is going to be Ms. Gant. Mr. Howard, any priors?
No.
Ms. Todd, any recommendation?
Yes, Your Honor. On September the 18th, Miss Yatira, I'm probably pronouncing this wrong, Yatricia, that's Ytreecia, Jones, common spelling, went to an APD precinct to report that she had been attacked by the defendant the prior day. According to Ms. Jones, the defendant hit her in the face with a remote control, leaving her with a busted lip. The defendant also body slammed Ms. Jones to the ground, leaving her with bruises on her elbows. Sadly, Mrs. Jones' 12-year-old child, whose initials are JB, were present during this altercation, and as such, the state will be adding, after today's calendar, a charge of cruelty to children in the 3rd degree. Our office was able to contact Ms. Jones, and she informed us that she and the defendant no longer have any contact, and inferred that there is no desire to have contact with the defendant. I will say that Ms. Jones is on the line if you would like to sound for her when it's appropriate. With this being such a crime that happened in front of a minor, Your Honor, the state is asking for a $4,000 surety bond, a stay away from 930 Howell Mill Road, which is where the incident happened, a no further contact with Ms. Jones, third-party transfer of the child that they share, and no drugs, alcohol, or weapons while on bond.
So you haven't accused her of the cruelty in the 3rd degree, correct?
We have not yet, Your Honor. I will be filing those charges as soon as we get out of court today, which is why I do have the $4,000 surety bond request, but that is only on the battery charge.
Okay. Ms. Gant?
I need to chime in real quick. It's a TPO too. The defendant is the victim in the TPO with the victim in this case.
Okay.
And that expires next year. No, that expires next month.
All right.
It was from February 2022 to next month. That's all.
February 2022 until end of March 2023?
Oh, I'm sorry. Okay, it was February 25th, 2022. That's when it was issued. It expires February 24th, 2023. So it was a year TPO.
Okay.
And I apologize, Mr. Howard, and you said that it was the defendant who took that out on the victim in this case?
Yes. So it's like reversed on the TPO from what's today. Yes.
I was about to say, it looks like she violated her own TPO in this case.
So just letting y'all know.
Thank
That's all.
You still want me to talk to the alleged victim?
Yes, Your Honor, whenever is appropriate. She does have a right to speak.
Oh my God. Okay. Miss Utrecia Jones.
Yes, ma'am.
All right, first of all, Miss Utrecia Jones, I've just heard from my pretrial officer, Mr. Howard, that apparently Miss Ebony Jones has an active protective order against you.
Yes, ma'am. We actually went to court to get that TPO wiped away.
Oh,
And I
good.
showed
Do you have the
proof.
case number, please?
Yes, ma'am.
2022 CB. I'm assuming it's a Fulton County TPO?
Yes, ma'am.
Your Honor, it is. It's 2022 CV 370392.
370392. Let's see how it was wiped out. The petition was issued. The petition was filed September 19th, 2022, which is long after February of 2022.
It was two, Your Honor. She went after the fact. She went and took another one out on me after I pressed charges. So that's the second one she took out on me.
So this is the second one.
Yes, ma'am.
And there was a continuance from October 6th and the TPO was never issued. There was a dismissal order on October 19th, 2020.
Yes, ma'am.
Okay. So, and there was a prior one?
Yes, ma'am. That was from February.
And
But
do
we
you
had
have
a
that
court
case
date.
number?
Your Honor, I believe I just found that case number as well. It's a 22 CV 360156. Let me see if I can find the judge's final order in that one. If you'll indulge me for one moment.
2022 CV.
Okay, I do see a note in here stating that this protective order was set aside, so it was not active either.
Okay.
Yes, ma'am.
So so there was no active protective order at the time of this incident. Okay.
No, Your Honor.
All right. Okay, Ms. Jones, raise your right hand. What would you like? Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, Ms. Utrecia Jones, only you. What would you like to tell me?
Actually, I just want to move forward with this case. I no longer contact my wife. We're still married. I'm filing for divorce. I was told that I couldn't contact her up until today. Someone called me and said that the TPO was set aside due to lack of evidence in October. So I haven't had any contact. We do share a child together. So the only thing I asked for is for a third party so I can see my daughter and talk to my daughter. She is 5. And she is legally mine.
So the daughter is living with whom?
She's living with Ebony Jones. But I can't have no contact. I was forced out of my residence.
All right. Thank you. Ms. Gant?
Yes, Your Honor, Miss Ebony Jones is 35 years old. She has been in the Atlanta, Georgia area for 1 year. She is the proud mother of 3 children, one of which she shares with the complaining witness, Miss Yatricia James. Her children's ages are 5, 12, and 11. She does not have any other family support here, Your Honor. Ms. Jones states that she is the primary caretaker of all of her children and that she is not receiving any child support. She completed high school. She also has some college. She studied logistics. She also is a veteran. She served in the U.S. Army for 6 years, and she is disabled as a result of that service, Your Honor. She states that she is still able to work at Lockheed Martin. She has been in that position for about 3.5 months. Your Honor, my client denies the allegations. This is her first arrest, and my client tells me that she is operating under the belief that the TPO is still in effect. She states that on this particular day in question, September 18th, 2022, it is Ms. James who actually attacked her. She states that my client states that Ms. James jumped on her in front of all of the children. She states that she choked her and that she threw something. She basically threw something at her, and my client was merely acting in self-defense. Because she does not have any prior history, Your Honor, and it appears that my client has filed the TPO orders, I am requesting a signature bond on Ms. Jones's behalf. Ms. Jones informs me that the 930 Howell Mill Road is actually her residence and that Ms. James doesn't live there. She was asked to leave that or ordered to leave that property because of these TPOs. She does not want to have any contact with Ms. James and Miss Yatricia. I have her name is Yatricia James. She doesn't want any contact with her. She also does not want the 5-year-old to have any contact with her at this time because, again, she's operating under the belief that the TPO is in effect, which bars Ms. James from having any contact with that minor child. Lastly, Your Honor, let's see here. Yes, that's basically my position, a signature bond. There is no request for a one-time law enforcement escort, as my client states that Ms. James does not have any property at the 930 Howell Mill residence, Your Honor. Thank you.
All right. This is more for information for Miss Ebony Jones, and just to correct any misinformation that's been provided or misconstrued information. The TPO that was filed by Ebony Jones, 2022 CB 360156. Miss Ebony Jones filed a motion in Superior Court to set aside the Family Violence Protective Order. She filed it on May 12th, 2022. Miss Ebony Jones and Yatricia Jones both appeared before Judge Manning in open court. And the judge granted Miss Ebony Jones' motion to set aside the 12-month protective order. So Miss Ebony Jones, you filed the petition for a protective order, and then you filed the motion to set it aside. So there is no active protective order against Yatricia Jones because you canceled it. Ebony Jones canceled the protective order. First thing I want to make straight. The second TPO petition that Ms. Jones filed was dismissed because neither party appeared to pursue that case. That case was dismissed. So there is no protective order against Yatricia Jones, but there is an active criminal case against Ebony Jones, which is more serious. Ms. Ebony Jones is granted a $5,000 signature bond through pretrial services. No further contact with Yatricia Jones, which means that Ebony Jones now has a legal duty to stay 200 yards away from Yatricia. She's not to contact Yatricia in person, through a third party, through a phone, a computer device, social media, or anything. You're not to discuss or even mention Yatricia Jones on any kind of social media platform. I'm going to allow for third-party transfer of the child that they share. So that means a third person must be available in order to carry out any visitation that is mutually agreed upon through the third party between Ebony and Yatricia Jones. And Miss Yatricia Jones, if there is no such mutual agreement, then the only other way in which you can get a schedule to see your child is through a divorce proceeding, where there can be a court order setting forth a temporary visitation and custody order.
Yes, ma'am.
Miss Ebony Jones is not to consume any illegal drugs, no alcohol, and not possess and own any firearms. So if you own any firearms, they have to be removed and surrendered to the authorities. While you're out on your signature bond, you will attend and complete the pretrial one-day anger awareness program. And your next court date will be sent to you at your address. What was that address, Ms. Gant? I'm so sorry.
930 Howell Mill Road.
Yeah, she can return to that location. I understand that Miss Yatricia Jones does not live there, so Miss Ebony Jones may return to that location. And be mindful that right now, contrary to what a TPO is, there is now a protective order against Miss Ebony Jones.
Yes, ma'am.
All right. Thank you.
Thank you.
Thank you, Your Honor.
Position 3, Brown.
Are we done with courtroom 3 then?
No, we're doing, going back and forth, Judge.
All right, courtroom 2, we have Dion Brown, accused of battery, domestic violence from January 12th, 2023. That's today, okay. 23 CR 0000194Y. And Mr. Brown, you've been advised of your right to remain silent, and your attorney is Ms. Gant. Mr. Howard, any priors?
I got second arrest. Last arrest was in November for battery DV. It was Judge Mincy, 5,000. Good bond was the bond.
All right, thank you. Ms. Dillingham?
Yes, Your Honor. This case occurred at 125 Economy Hotel, where officers responded to a argument that had erupted between defendant and the victim, Brian, who also goes by Kevin Fountain. The two were staying together in the hotel when the defendant punched the victim in the face unprovoked. Upon officers' arrival, they observed swelling to the victim's eye. And Your Honor, as it was just mentioned, there is a case from November of 2022 of battery against the same victim. And Judge Mincy ordered not only a $5,000 good bond, but also a no further contact with this victim. And this defendant violated that order, not only in seeing him, but in assaulting him as well. And so for that reason, the state is requesting a $6,500 surety bond, no further contact with Brian, also known as Kevin Fountain, and no drugs, alcohol, or weapons.
Judge.
Yes.
Yeah, my bad with this history. It's been a long day. He actually got 7 total. So let me
Do you have the open case number?
Yes, Your Honor. It's 22 CR 0075556E.
Okay, and I'm sorry, Tucson, did you have anything else to add?
He got history out of North Carolina, 2017, felony larceny, eluding, that was dismissed. 2016 out of Virginia, failure to appear. 2016 DWI, 2013 assault on law enforcement, that was dismissed. Disorderly conduct conviction. And 2010 petty larceny. That's it.
Ms. Gant?
Yes, Your Honor. Mr. Dion Brown is 30 years old. He has been in the Atlanta, Georgia area for about 1 year. He states that he does not have any other family here. Mr. Brown completed 12th grade. He studied IT in college. He did not graduate. He states that he has been unemployed for about 3 months, 3 to 4 months, but just found a job at Publix. He completed training and he was set to start work yesterday. Now, Your Honor, my client informs me that Brian Fountain and Kevin Fountain are actually family members, that they're related and that they're not the same person. I do not have in a birth date or anything to verify that the two people, Brian and Kevin, are the same people. But at any rate, he strongly denies the allegations. He states that Mr. Brian Fountain is basically on a mission to be vindictive toward him because Mr. Brown, had been homeless. He's now living in a hotel. He's trying to get himself together. He just found work. So he states that these are false allegations against him because Mr. Fountain doesn't want to see him do well. My client is presumed innocent in that open case back in November. He's presumed innocent in this case as well. He certainly denies the allegations. I am requesting a signature bond on Mr. Brown's behalf. And if Your Honor determines that he's ineligible, then I would ask for the lowest bond possible as he's not, has assured me that he's not going to be able to make bond. And furthermore, he needs to get back to that hotel so that he can retrieve all of his belongings because he's at risk of losing everything. Thank you, Your Honor.
And Your Honor, if I may just clear up that allegation regarding the Brian and Kevin Fountain. Our victim advocate has spoken with Brian, aka Kevin Fountain, on both occasions, on the first incident. And just to shed a light on that incident, the defendant beat Mr. Fountain with a Swiffer stick, causing a lump to his head and a busted lip. So these two have been in a relationship for about 5 months, and this is the same person. It is not a family member.
Is there a Mr. Fountain on the Zoom? I see a fountain there, but I need that person to unmute and start video.
Hi, Yana.
You need to start your video, sir.
Yeah, I started. Hello? Hello?
First of all, sir, you're in court. Can you go put a shirt on?
Yes, I was getting ready for work, ma'am. My apology. Hello?
All right.
And Your Honor, also, I do apologize for interrupting. My client has expressed that he wants to have no violent contact with Mr. Fountain. However, we will defer to the court's ruling.
Which one? Which one?
I'm sorry?
No violent contact with whom?
Brian Fountain.
Mr. Fountain, have a seat. Sit down.
Okay.
Jesus. All right. Now, I'm going to place you under oath. Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
What is your legal name?
Kevin Fountain.
I'm going to ask you one more time.
I just told you my name is Kevin Fountain.
No. You don't get to snap back. What is your legal name?
I just told you again, Kevin Fountain.
Do you have a middle name?
James.
So your legal name is Kevin James Fountain.
Yes.
Who is Brian Fountain?
I have no idea. Hello.
Excuse me, Your Honor, if I may, Brian Fountain is the name that this victim gave to officers when they arrived.
All right.
On body cam footage.
Mr. Kevin James Fountain, are you the individual who was at 9995 Old Dogwood Road in Roswell in Fulton County on January 12th, 2023?
Yes.
Were you also the individual who was the alleged victim in a prior case involving Mr. Dion Brown?
When was this? Yana, you there?
I'm listening.
Oh, yeah, when was that case?
It was November 3rd, 2022.
I can't quite remember that because I do have like, I don't know, a memory loss, like, but the incident yesterday, pretty much the police was called. When the police was
No,
called,
I'm just interested to know whether you were the individual involved with Mr. Dion Brown on November 3rd, 2022.
I don't remember that.
Yes. Thank you. You may mute your screen. All right. I'm fairly confident that Kevin James Fountain is the individual involved in both cases, unless I have something to the contrary. So, and I'm looking at the court order issued by Judge Mincy. The bond order issued on November 4th, 2022 set Mr. Dion Brown's bond at $5,000. It was a good bond. No further contact with Kevin Fountain. So I guess that was the situation. Okay. Ms. Gant, anything else to add?
Nothing at this point, Your Honor. Thank you.
All right. Mr. Dion Brown, you have a right to remain silent. Anything you say, your statements can and will be used against you. If you choose to waive your right to remain silent, you could end up incriminating yourself and damaging not only your defenses in this case, but in the prior case as well.
And Mr. Brown, my advice to you is to remain silent. I'm happy to call you after this hearing to answer any questions that you have.
Okay. Bond is set at $10,000. It is a surety bond. No further contact with Kevin James Fountain, also known as Brian Fountain. No illegal drugs, no alcohol, no weapons. To stay away from 125 Economy Hotel in Roswell. He may return one time only with a police officer to retrieve his personal belongings. Mr. Dion Brown, no contact means that you cannot speak to Mr. Kevin Fountain or Brian Fountain, whichever name he goes by. You cannot speak to him in person. You cannot speak to him by phone, by any kind of computer device, not through a third party, and you're not to communicate with him on social media. The phones at the jail are monitored, and if you attempt to communicate with him in that manner, your bond will be revoked.
Your Honor, I do apologize for interrupting and certainly respect your ruling. I guess I just need a clarification. My client informs me that he is renting a room at 9995 Old Dogwood Road in Roswell, and that Mr. I guess Kevin, also known as Brian Fountain, does not reside there. So we are, I guess, wondering why there is a stay away.
It's a commercial property, lodging property, and unless the economy lodge is perfectly happy with him coming back, I'm going to require him to stay away.
Thank you. Understood, Your Honor.
All right. Our next court date is going to be January 26th. If Mr. Brown has nothing else to say, we can move on. All right. Next case. Yes, Mr. Brown?
Mr. Brown, please remain silent.
Position number 2.
Thank you.
Ma'am, I understand what my defendant is telling me to do. But I just want to respectfully say something to you, ma'am.
Mr. Brown, please remain silent. I'm happy to give you a call at the jail. We presented our arguments. The judge has ruled.
All right, thank you.
I do apologize, Your Honor.
That's all right. Position number 2, I have Wykedria Berry. Is that the lady in courtroom 3? Ms. Berry, if you are the individual in courtroom 3, could you please raise your hand? Okay, thank you.
Your Honor, if I may request a breakout room for this case, there are some matters that need to be discussed in private.
Okay, we're gonna go to another case then, Judge. She can be last.
Thank you.
Position number 30.
2, 9, and 12 have to be last. Okay.
Okay.
Repeat that, Judge, who was it?
I'm sorry, position number 8, Ms. Jones, please.
All right, thank you. Melissa Brown Jones, case number 23 CR 0000197B, accused of improper erratic lane change and driving under the influence of alcohol less safe from January 11th, 2023. Ms. Jones, you've been advised of your right to remain silent. Your attorney is going to be Ms. Kim.
Yes, Your Honor.
Priors, Mr. Howard?
No.
Okay. And Ms. Todd?
Thank you, Your Honor. Yesterday, officers found defendant's vehicle in the front yard of a residence located in the roundabout near Norcross Street and Warsaw Road. When officers spoke to the defendant, they noticed that her eyes were red and watery, her speech was slowed and slurred, and her breath smelled of alcohol. The defendant not only admitted to the fact that she had no idea where she was at the time, but she also admitted to drinking prior to driving. The state is asking for a total $4,000 surety bond, Your Honor. That is $3,000 on count 1 and $1,000 on count 2, as well as no driving without a valid license through DDS, and no drugs, alcohol, or weapons while on bond.
Ms. Kim?
Yes, Your Honor. Ms. Jones she was born in 1982, and she's been here in Georgia ever since 2005, so almost 17 years. She's been driving as for Uber Eats, and Your Honor, she also has a bachelor's degree, and because of her low income, she's qualified for public defender's service. And $4,000 surety bond is very burdensome financially, so we would like to request for a maximum $1,000 good bond for total. And that's it, Your Honor. Thanks.
On the erratic lane change, it's going to be $500. On the DUI, it's going to be $1,500. That's a $2,000 surety bond. No illegal drugs, alcohol, and no weapons and firearm. Next court date is January 26th. If she makes bond, she needs to make sure that we have her current address so that we can send her notice of a next court date. Her driving privileges will be governed by the Department of Driver Services. Upon being arrested for DUI, your license will be suspended and you're only granted a 30-day driving permit, after which your license will be suspended unless you file the appropriate paperwork with the department. Thank you.
Thank you.
Courtroom 2, who do we have?
This is going to be position 5, Ellie. Keep your mask up, please.
Judge, I do apologize. Could you give me Ms. Jones' bond amount again, please?
The DUI is $1,500. The erratic lane change is $500. It's a surety bond, no alcohol, and her next court date's January 26th.
Thank you.
All right, we have Demarius Ellie, case number 23 CR 000192E. Mr. Ellie is accused of simple battery domestic violence from August 3rd, 2022. You've been advised of your right to remain silent, and your attorney is going to be Ms. McLeod.
Good afternoon, Your Honor.
Good afternoon, ma'am. Okay, let's begin with Mr. Howard. Mr. Howard, any priors, please?
My coworker got that file. He went to felony earlier, so I have to go get it.
All right, let's see if our prosecutor may enlighten us. Ms. Todd?
Yes, Your Honor, I will definitely be able to give you his history. He does have 5 total cycles. I will start with the facts as his cycles do become relevant throughout them. What started as a verbal argument between the defendant and his mother, Miss Monet Ellie, that's M-O-N-A-E, last name is spelled the same as the defendant's, turned violent when the defendant placed his hand around his mother's neck and choked her. In the statement she provided to police, Miss Ellie stated that this was not the first time that her son has put his hands on her. She also stated that it is her intention to get a TPO against her son and that she doesn't want him to come back to the home. Our office has not been able to contact Miss Ellie. However, we would like for you to sound her if when the time is appropriate. As I stated, defendant has 5 cycles. 4 of those are active cases in Fulton County. The first one is going to be 21 CP 202689. That is a possession of firearm or knife during the commission or attempt to commit a crime, a felony, purchase, possession, manufacture, distribution, or sale of marijuana. There is also the 21 CP 202691, which is the purchase, possession, manufacture, distribution, or sale of marijuana. There is 21 CP 204948, which is theft of lost or mislaid property. And then the felony case that he has open as of today, Your Honor, that he was at first appearance for this morning is 23 CP 215362. And that is for the possession of a firearm or knife during the commission or attempt to commit a felony, aggravated battery, and aggravated assault, Your Honor. We are clearly concerned with the risk of reoffending, as he does have 4 active cases, not including this one in Fulton County. We are also concerned for the safety of the victim in this case, Your Honor. She is the 41-year-old mother of the defendant, and therefore he is in a unique position to try to influence her actions in the judicial process. We are asking for a $2,500 cash bond, Your Honor. We are also asking for no further contact with Miss Ellie, a stay away from the incident location of 866 Marion Avenue, and no drugs, alcohol, or weapons while on bond.
Ms. McLeod?
Yes, Your Honor. My client is 20 years old. I was able to speak with his mom, and she denies the allegations made in the prosecutor's arguments and also in the warrant. In fact, my client tells me that this alleged incident happened, I believe, in early July of last year. When I spoke with mom, she tells me that the facts as stated by the prosecution are widely exaggerated. She denies that her son put his hand on her at all, and she tells me that they have continued to live together since then, and they've been living together all this time, and that she did not tell the police that he had choked her or done any of those things to her. I believe she may be on the Zoom. She was at work when I spoke with her, but she told me she was going to try to come on the Zoom. Your Honor, my client, he tells me that he works at McDonald's. He has a child on the way. I think the child should be here in another 2 months, Your Honor. He tells me that he currently lives with his stepmother. And he also denies that anything happened with his mom. He says, you know, they were just having an argument. And it was not violent at all. As the prosecutor says, he did go to felony, and I understand that he did not get a bond, Your Honor. He's not in a position to pay any money. All he has is a job at McDonald's, which of course he doesn't have now because he's arrested, and he's unlikely to get out since he doesn't have since he was given no bond in felony. So I would ask the court to take all of that into consideration in setting his bond. But I would like to say that his mom denies these allegations, and she would like him to be able to interact with her. Nothing further, Your Honor. I believe she is on the Zoom.
I'll check. Monet Ellie, are you with us on the Zoom proceeding? You have to start your video and unmute your screen.
I'm gonna sit your house off, everybody.
I'm here, but I can't start the video, ma'am.
Well, I won't be able to address you unless I can see. There you are. And you need to put the cigarette out. Thank you. All right. What's your name, please?
Monet Ely.
All right. Miss Ely, if you'd like to raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
So, Miss Ely, I've already placed you under oath, so you're required to testify and make only truthful statements, otherwise subject to the rules of perjury. I just also like to advise you that I'm reading the warrant that was signed by the judge from the incident involving you and your son, Demarius, and the entire incident was recorded on body cam video footage. So if you say anything that contradicts what may appear on the footage, you may be subject to criminal prosecution as well. So
Okay.
at this juncture, is there anything you'd like to say? Or if you have nothing to say, you can also proceed accordingly.
You talking to me?
Yes.
No, I don't have anything to say.
Moving on, anything else, Ms. McLeod?
Nothing else, Your Honor, except that mom did say that she would like to have contact with her son and she would like him to be able to come around her, come home if he wants to.
Noted. Thank you.
Your Honor, if I may, the victim is on the line right here and right now. And if she wished to have asked for those things, she could have asked for them now. Based on the information in the warrant and in the police report, it is obvious someone called the police that day, and Miss Ellie's statements at the time were that he did choke her. So we would like you to take that into consideration.
The original warrant was for battery, domestic violence, and y'all have accused it now as simple battery. I mean, which way are we going on this one?
It is simple battery, Your Honor, simply because when the officer spoke to the victim in this case, she didn't have any visible marks that were reported.
Okay. Bond is going to be set at 4,500. It's going to be a surety bond. No further contact with Monet Ellie. You're not to communicate with...
Is it possible I can say something?
Yes, ma'am. What would you like to say?
Since that day, me and my son has been in full contact and we get along just fine. Now, me and him talk every day on a day-to-day basis. So far as me wanting to have him charged, I don't want to have him charged. Right now, our relationship is a lot better. We're working on going to counseling together. So far as me want to press charges against my son, no, ma'am, I don't.
The decision to press charges is really with the solicitor's office. After the case has been accused, the solicitor would make the decision as to whether to drop the charges. Considering the nature of the open cases against Mr. Ellie, I am not going to grant any contact at the present time. As I was saying, no further contact with Monet Ellie. If he engages in any form of communication, including calls from the jail, he could risk his bond being revoked. No alcohol, no drugs, no weapons, and to stay away from all properties involving Monet Ellie. Thank you. Next court date's January 26th.
Your Honor, will you...
Ellie, you have the right to remain silent and don't speak. You can call me on the phone. I can clarify anything that you want to clarify, okay?
All right, courtroom 3, who do we have?
When you gonna come see me? What, it muted?
I'm sorry.
I'm moving on to courtroom 3.
I'm sorry, but can I just please have Miss Ely message me in the chat her phone number so that I can reach out to her?
All right.
And Your Honor, I apologize. Would you be adding a no drugs, alcohol, and weapons to that
Yes,
bond? Thank you.
All right. Miss Ely, if you know how to use the chat feature on your phone, you would need to Miss Iman, if you can send her a chat message to respond to you. She can do that.
Thank you.
Mr. Jordan, all right, can we mute Monet Ely, please? Courtroom 3, who do we have, please?
Position number 13, Judge.
Thank you. This is State versus Jasmine Wade, accused of simple assault, domestic violence on June 15th, 2022. Ms. Wade, you've been advised of your right to remain silent, and your attorney is going to be Ms. McLeod.
Yes.
Mr. Howard, any priors?
It's a fourth arrest. Hold on. All right, last arrest was 2007, FTA ag assault. Disorderly conduct 05 conviction. And a simple battery DV dismissed. That was from 04. That's all I have.
Thank you. Ms.
Hold on.
Ms. Duncan?
Yes, Your Honor, this incident did occur on June 15th, 2022 at 876 Hall Street Southwest. The victim in this case is Derek Johnson. That's D-E-R-E-K Johnson, last name common spelling. What had occurred in this incident, Your Honor, is that apparently there was a verbal altercation between the victim in this case and the defendant. And during that verbal altercation, the The defendant in this case became irate and angry, and she swung at the victim and knocking his cellular phone out of his hand. Her victim advocate did get a chance to speak with the get a chance to speak with Mr. Johnson in this case, and he did state that he doesn't want any contact with this defendant and would like third-party transfer of 3 children that they shared together. Mr. Johnson did provide our office with the video footage captured from a cellular phone of the incident, and it is in accordance with what he stated to officers. He also indicated that initially he called the police that day and had to wait for a long time. So he went to the precinct and filed the report. He states that they were in a relationship on and off for 11 years. Given this defendant's violent convictions in the past, we are going to be requesting a $2,000 surety. Even though it is remote, it does show a pattern of behavior. Given this victim's wishes, we would ask for no further contact. Stay away. I'll place the defendant's new address in the chat. I would like the court to let me know who to send that to. We'd ask for third-party child contact, no alcohol, drugs, weapons, or firearms, and no further violations of Georgia law.
I guess you could send it to Mr. Michael Jordan unless we have another litigation manager who's assisting. In the meantime, Mr. Derek Johnson, did you want to address the court about this case?
She basically covered everything. This is the ongoing thing.
Okay, and that's it then.
Okay, say no more.
Ms. McLeod?
Yes, Your Honor. My client is 36 years old. She is the mother of 3 children, a 10-year-old, 11-year-old, and an 8-year-old, for whom she's always been primarily responsible and still continues to be responsible for this day. The alleged victim, Mr. Johnson, is the father of these children, but he's been an absent father in that he's spent most of his adult life in prison. He recently came out of prison, and my client allowed him to stay with her for a little while because he was in transit. She did not want a relationship with him, and she indicated that to him. He became angry and he struck her. She struck him back, and that was what he caught on video. He did not, of course, go to the police then, but when she told him definitively that she wanted him out of her home, he decided that he would go down to the police precinct and he would get a warrant against her. And this is the reason why this warrant exists, Your Honor. My client is the legal parent, Your Honor. These children are not legitimated and they were never married. She doesn't necessarily want him to have unsupervised contact with these children, Your Honor. So this third party transfer and so on, we are opposed to that, Your Honor, because he's not a good influence on these children.
Your Honor, just to clarify, for defense's contentions, from what I saw in the video that I watched that was provided by the victim in this case, there was a verbal altercation. However, the defendant in this case seemed to be primarily aggressive towards this defendant, and she did approach him and attempt to strike him at that point, knocking the phone out of his hand and all of this.
That is what you saw, but they were having an argument prior to that.
Is that video going to be shown?
Let me check with my supervisor.
No, most likely not. So we're just going to move on to the issue of bond.
Okay.
Ms. McLeod, does your client still live at the Hall place?
She does, Your Honor. It's her home.
Hall Street?
Yes.
She does not.
It is
her home. She lied about everything.
All right. Mr. Jordan, you can remove the, yeah, thank you. All right. Is that her current address?
It is her current address. It's her home where she resides with her children.
All right. Well, the problem is that if Mr. Johnson lives there, then she cannot return to that location.
It's indicated that they were both living there initially, but we were told that neither one of the parties.
No. Listen very carefully. Is he currently living there?
No, Your Honor, respectfully.
No, Your Honor. And they don't live together. She lives at an address. She had to move to get away from him.
I went and got an eviction notice out on him. That's how all of this started.
Stop.
Your Honor, I've provided the new address where the defendant lives to the litigation manager, Michael Jordan, as requested by the court.
All right, Mr. Jordan, do you have the defendant's new address?
Yes, I do, Judge.
And could you just give me the street name, not the street number?
It's Hall, Your Honor.
It's what?
Hall.
Oh, it is the Hall Street location then.
It is not.
No, Judge. It's a West Sherwood Drive address. It's a different address. Different address, different city.
Ms. McLeod, any idea why we have a different address?
This is where my client tells me that she lives, Your Honor. I have to go by what she tells me. She has no reason to lie to me about where she lives.
I think your client will need to tell me where she lives. Okay, unmute courtroom 3, please. All right, Miss Wade. I don't want to know about any dispossessory actions. I don't want to know about any eviction notices. I don't want to know about any of that. What I want to know is that when you were arrested, just before you were arrested, where were you living? West Sherwood or Hall Street?
I turned myself in. I turned myself in.
When did you turn yourself in?
I turned myself in yesterday.
Okay, yesterday was January 11th, 2023. Before you, which house did you leave to go to the jail?
Okay, so I'm staying at the 876 Hall Street. I had to temporarily move out because of everything that was going on with him.
Okay.
I have Atlanta
So,
house.
Ms. Wade, where is your current address? What was your last current address before you went to turn yourself in?
Ma'am, I don't want him to know my address. He has been
You have a
stalking and
West Sherwood.
harassing.
Listen
No,
very carefully.
no, that's not it.
All right.
Your Honor, to clarify.
That's his address on 920 West Shoal Street in South Carolina. That's his address.
To clarify, Your Honor, that's not the address that the victim has provided us. They do not live together according to what has been told to us. And I have provided the litigation manager with the address at where the victim currently lives, which he does not want the defendant to know. That's why I put it in the chat to Mr. Jordan.
And my client does not want him to know where she lives either.
Well, somebody needs to let us know so we can send you all an invitation to show up in court.
Mr. Jordan has
996 Washington Street. That is the address he has for me, that he can come and visit his children at. Is 996.
No, Miss Wade. You don't get to decide visitation right now, okay?
I'm not
Listen very carefully.
Your
Listen
Honor,
very carefully.
with all due respect, she does.
I'm going to put a $10,000
children are
cash
not
bond and then we
legitimated.
can deal with this in 2 weeks' time. Shall I do that? Okay. Miss Wade, your bond is going to be set at $5,000. It's going to be a signature bond through pretrial services. Before you leave, you need to provide your current living address to the deputy who's seated next to you. You don't have to say it out loud. And then the deputy will send it in the chat to Mr. Michael Jordan, the person who puts it on our file. Do you understand?
Yes, ma'am. So he is not going to get my
Listen
address.
very carefully. I've just given you a signature bond. Do you want me to change it to a cash bond?
No, ma'am.
You are to have no further contact with Derek Johnson. You may return to your home with your children. How many children are there? 3?
3, Your Honor.
You may return to your home with your 3 children.
831. I mean,
And Miss Wade, with regards to the 3 children, were they born in wedlock or outside?
No,
wedlock?
Your Honor, they've never been married. The parties
Okay.
have not been married and he has not legitimated those children.
Thank you. Mr. Derek Johnson. We can unmute him because he's about to be in trouble. You can unmute your screen, sir. You can unmute your screen.
Oh, I did not let you all mute me.
We did, because you kept interrupting.
I didn't mean to
Listen very
interrupt.
carefully. Listen very carefully, because in the eyes of the law, when you have a child that's born out of wedlock, you have no rights to the child.
Correct.
No rights to visit, no rights to see, no rights to have custody, none. You would have to file the appropriate civil action in the correct superior court to get a court order for visitation and custody. So presently, you're not supposed to be in the same location with the 3 children. Miss Wade, you may return to your home and you have custody and you have full custody over the 3 children that you share with Mr. Johnson. Of course, if he files a legitimation action, you would need to respond to that and let the judge know that you have a no further contact with Mr. Johnson, so the judge can conduct the hearing appropriately. Do you understand?
I understand.
All right.
Yes.
$5,000 signature bond through pretrial services. While you are out on bond, Ms. Wade, you're not to consume any alcohol, no illegal drugs, and not possess any weapons or any firearms.
She has a firearm committed. Take that.
Mr. Johnson, now we're going to mute you again because you don't know how not to keep your mouth shut. As I was saying, Ms. Wade, you're not to consume any alcohol, no illegal drugs, and not possess any weapons or any firearms. You have sole custody of the 3 children in question. Mr. Johnson does have a right to file a legitimation action to get a court order to establish visitation and custody. You may return to your home and your address should be provided to the deputy who should forward that to Mr. Michael Jordan. When you are reporting to pretrial once a month, you are also to attend and complete a 1-day anger awareness program with pretrial services. Make sure that we have your current address so you don't miss out on your next court date. Otherwise, a bench warrant will issue for your arrest. If you believe that Mr. Derek Johnson poses a threat to you, you have a right to file an action for a protective order against Mr. Derek Johnson. And I will put down in the bond order that Ms. Wade does have a right to file a protective order based on their history of domestic violence between the parties. Thank you.
Miss Wade, you can call me. I'm prepared to answer any questions you have. Once you get out, give me a call.
Thank you. That concludes this case. I'm moving on to courtroom 2. Who do we have, please?
12 Roberts.
Yeah, how's everyone doing?
Jeremy Roberts, was that correct?
Yes.
Your
Okay.
Honor, this is one of the cases that we'd like to hold till all the other defendants have gone on the calendar.
Okay, hang on. Let me see if we addressed all the other cases.
I have my last 2 judge in here, position 9 and 12 is my last 2 in courtroom 2.
Okay, and in courtroom 2, what position is that? That's position 9, isn't it?
Yeah, you guys wanted positions 12 and 9 to go last. These are my last 2.
Okay.
All right, and I had position 2, 9, and 12. So there should be 3 cases left.
No, I have position number 14 in courtroom 3.
Okay, let's go to position 14 in courtroom 3. This is Leia Wingo-Delegel, hyphenated, charged with battery domestic violence from January 10th, 2023. Ms. Wingo, you have been advised of your right to remain silent. Your attorney is going to be Ms. Kim. Any priors, Mr. Howell?
Oh, first arrest.
All right. Ms. Duncan?
Yes, Your Honor. In this case, it did occur on January 10th, 2023 at 5119 Barrington Trace Drive Southwest in the city of South Fulton. Officers were dispatched to that location in reference to a battery. They made contact with the victim in this case, who is John Delegel. That is JOHNDELAIGLE, who is the current present spouse of the defendant in this case, Your Honor. It was indicated to officers that there was a verbal dispute that turned physical when his wife came into his office and slammed his laptop computer closed and began questioning him about some incidents that had occurred several years before. He tried to leave and de-escalate the situation. She blocked his exit from the room. She knocked everything off the desk and she came after him, scratching and striking him. The victim, my apologies, did sustain visible injuries, including a bite mark where skin was broken that the officers notated, as well as bruising and lacerations to his face and neck area. We, in this case, have some concern about the risk of reoffending, given that these parties are married and that they do live together. And specifically in this case, Your Honor, we do have some concern about the risk of intimidation of this witness. Our victim advocate was able to speak to the victim in this case, and we do believe the victim is on the line and does not want to proceed. However, that goes to our concern about intimidation. This victim did in fact call this defendant did in fact call the victim 9 times since being incarcerated. And of those 2 times when the defendant did make contact with this victim, she berated and blamed the victim in this case for her circumstances and threatened him at that time that their marriage was over. So this continues to be what seems to be an involving violent situation. And since it did just occur and there's violence with injuries alleged from the victim in this case, we're requesting a $3,500 surety.
Which call was it where she allegedly threatened him? You said there were multiple calls.
She called 9 times, Your Honor, since she's been incarcerated, and there were 2 calls where the victim actually accepted the call. And on both of those calls, Your Honor, she made berating statements. And
do you have a date timestamp of those calls?
They're on
the 2 calls?
One moment. I would have to pull them up. We have them on evidence.com, and I did in fact get to listen to them. Our investigator would be able to provide me with the specifics, but I do have them on evidence.com, and I have heard.
If I just have a date, this occurred on January 10th. Today is January 12th, so it's anywhere between January 10th and January 12th. Yes. Unless, of course, Mr. Delegel wants to confirm that he accepted 2 calls from Mrs. Delegel. I can't hear you.
Yes, I did, and I accepted them willingly.
All right, thank you. All right.
May I speak?
No.
Your Honor, I'm sorry to interrupt, just to fill in the question that you asked. It was January 11th at 9:53 a.m., January 11th at 3:27 p.m.
Thank you.
And in addition to, if I may continue briefly, yes, our $3,500 surety request, given the nature of the offenses alleged and the possible intimidation in this case, we're going to ask for no further contact to stay away from the location as listed on the record previously, 1-day anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Thank you. All right, Mr. Delegel, if you'd like to contribute to this hearing, I'll need to place you under oath. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. What would you like to tell us?
Well, there is no intimidation because I'm not intimidated by my wife. My wife suffers from a lot of pain, anxiety, and depression. And I'm sitting on my steps because there's quite a big wind going on around me. She has quite a bit of medications because of the pain and stress that she goes through. The last week has been extremely painful for her. I've called her a psych doctor and have an appointment tomorrow for her so we can get whatever imbalance is going on right now with her medications back to where she should be. She has been triggered based on those anxieties and pains that she has, which is continuous. I'm her sole provider. I'm her sole transportation to her medical facility and treat.
All right, thank you. Ms. Kim?
Yes, Your Honor. Ms. Leia Wingo-Delegel is actually 52 years old, and she has been here in Georgia ever since 2003. She graduated from Columbus State with a bachelor's degree. Her major was financing, and she moved from Ohio to Georgia. She wants to have a no further violent contact, same as Mr. John, who was testifying that he's not afraid of my client. Your Honor, my client is entrepreneur. She also owns and operates a school in West Africa, and she's been doing that ever since from 2015. My representation will end at the end of the bond hearing, since she's not qualified for public defender's service. We would like to request for signature on bond, since this is her first arrest ever. Thank you.
Bond's going to be set at 7,500. It's going to be a signature bond through pretrial services. Typically they mention who was the one who called the police, but I don't see that in the incident report.
It was the victim in this case. It said they made contact with the person who complained.
Okay.
And it was the victim.
Yeah, it's a 7,500 signature bond through pretrial services. There shall be no further violent contact with John Delegel. Mrs. Wingo can return to the marital home, but there cannot be any future violent physical or verbal altercations where the law enforcement get involved again. You have to be compliant with all treatment, medication, and counseling that is provided for you.
Hello? I'm sorry, I lost video. I don't know if and you're froze. I didn't hear anything. And I'm back online now.
Bond is
sorry.
set at 7,500 signature bond through pretrial services. There's to be no further violent contact with John Delegel, which means there cannot be any future physical or violent altercations between the two of you. If there's any reported altercations, the person coming back to jail is Mrs. Wingo with a 7,500 surety bond or cash bond only. She may return to the marital home, but she has to be compliant with all medication treatment and any kind of other health treatment that she's receiving. If she fails to be compliant with such treatment, that could be also grounds to revoke her signature bond. She's to report to pretrial once a month. She's not to consume any alcohol, no illegal drugs, and there not to be any weapons or firearms in possession of Mrs. Wingo, in the home, in the vehicle, or anywhere near her. Are there any such firearms at home? Mr. Delegel?
I gave those to the officers on the day of, and they
Okay.
had since subsequently returned them to me.
Well, they need to be gone now. So you can either surrender them to the authorities or you can put them in a safe deposit box to which she has no access.
Very well.
All right, her next court date is going to be sent to the marital home and she will need to appear in court. Failure to appear will result in a bench warrant for her arrest. Thank you.
And Your Honor, respectfully, the state would like it noted for the record its objection to the signature bond and the battery family violence where injuries are alleged.
Thank you. So noted. Okay, I think the only cases left now are positions 2, 9, and 12. Barry, and then the 2 cross-defendant cases. Is that correct? Okay. Who needs to be in a breakout room for this case? All right, Mr. Jordan, it appears is me, Miss Kim, Miss Dillingham, Miss Falk.
Your Honor, I do apologize for interrupting. For position 2, I am appointed.
Oh, I'm see. Oh, and Miss Gant. Thank you.
Which number you doing right now?
I'm going to do 2, 9, and 12 in the breakout.
Okay, I'll be back.
Your Honor,
In that case, Your Honor, I need to be in the breakout room.
my apologies. I don't mean to interrupt, but we're not requesting a breakout for 9 and 12. We were just respectfully asking that the courtroom be clear due to the nature of the offense.
We're going to in a breakout.
Your Honor, my client's mom is here.
Just the attorneys. I just need the attorneys in the breakout. That's all.
And the state would like to respectfully object to the breakout room for 9 and 12 on the record.
Okay, so put a caption, but Mr. Jordan needs to know who goes into the breakout, so let us know.
I don't think we need the breakout room for my client's case, Your Honor, and I think the state is saying the same thing.
Okay.
So,
Mr. Delegel, you're free to go. Francois will be with you very shortly. Thank you.
so to clarify, are we doing the breakout room for 9 and 12
Yes.
as well?
Yeah, you'll see a message on your screen.
Okay.
Does Ms. McCall need to be in that breakout room?
Yes.
Oh,
all-
absolutely.
Okay.
Myself as well.
Okay, so just to clarify, because I want to make sure I'm
Miss
clear. on
Fault,
this.
Miss Fault, no questions. Just wait for the breakout. Then you'll get then you get to ask questions.
Your Honor, I want to ask this question on the